Shalom, brothers and sisters. It's your brother Wasilkamilbey coming at your sham stoppers. I had to reload. I was having problems with this video. It's 1 o'clock in the morning. This is called Pt2 Moor-runs. Alright. We got that lady Taylor, Miss Taylor, out of maternity leave. You know, her coochie hole had healed up. You know what I'm saying? Wrote her a nice little beautiful letter. Mike Conley got it and gave it to her and threw her ass up on the bus. Like, nah, bitch, they talking about you, not me. So, you better handle that. That's what you better do. You gonna come over here and be a man in this man's world? That's what you gonna get. But anyway, let's get to it. Bring some more shit down to you. Check this out. Now, he is the petitioner. She is the respondent. Okay? And I guess she wants to be the counsel of record for our brother. You know what I'm saying? Which petitioner means to beg again. Of course, y'all know what that is. We don't beg around here. We make demands, you know, because they work for us. We don't work for them. You know what I'm saying? Without us, they wouldn't have a job. So we got to show them some love. Okay? Especially when they being disobedient public servants. Laura E. Taylor. Now look. The undersigned will make the motion and tender the order attached to it. Let me break it down to you again. One more again. Okay. Tender. Bid a request for project financing notice by the seller of a future contract of his intention to deliver a commodity or a financial instrument, offer of payment owed to a creditor, and offer to settle up an obligation, for example, to tender a check. That's it. Legal tender a cash offer in payment of an obligation. Offer to purchase securities, specific price called tender offer. But check out number 3. He is the creditor, people. They owe him money. Okay? They owe him money. They really do. Tender. Look at that. Unconditional offer to pay, perform in full an obligation to another, together with actual presentation of the thing or sum owed, or some clear manifestation of ability to pay or perform. See also legal tender. You know what I'm saying? You want to get down to the nitty gritty? Now, tender of delivery. Now, may constitute. Check that out. Tender offer, tender. Okay? They owe this man some money. He didn't apply for a loan. His baby mama did. She didn't give that money to him. You know what I'm saying? That's his account. And that's his property, his offspring. So no, he ain't got it up for sale. But check this out. Let's break this shit down again. Comes to the Commonwealth of Kentucky intervening. He's not a beggar. Herein by the Title 4A, Title D, Council moves the court to schedule a hearing on the attached such and such as our paperwork, which the cabinet has received from the petitioner pro se. Ain't a such thing as pro se, okay? It's really prosecutor. They don't want you to know you can prosecute them too. Yeah. The streets got prosecutors. Although the petitioners notices are not styled or designated. Yeah, because we don't use y'all shit. We don't have to. As such, it appears. A man cannot appear, but a ghost can, a dead entity, and do it is like 5 or 6 definitions of appear. What law requires a man to appear? There ain't none. That he is requesting a determination of arrears. No, we ain't requesting nothing. We demanding property back. You know what I'm saying? And or requesting to be relieved from the agreed judgment of paternity. What judgment of paternity? So they're acting like the creditor when they're not, and he's the creditor. Okay? It's this trick ritury they playing. Entered on October the 6th, 2014, excuse me, which he signed with his former legal counsel, which is gone, okay? However, that judgment and temporary support order have since been referenced and incorporated. There we go, financial term, all right, incorporated, all right, a business, okay? A lot of business can be incorporated. Listen what I just said. Circuit custody action filed by the petitioner through the same legal counsel by the court's final order entered. See, they talking about shit in 2015. This ain't 2015. It's 2017. All right? The intervening petitioner position, is these notices do not constitute, then we just read on constitute, either a timely or adequate appeal. We don't file appeals. Or motion. We don't do motions for relief. Okay? We don't have emotions. We have facts. The judgment of paternity or either the court's orders of support. Okay? So they saying the intervening petitioner's position is that these notices do not constitute. So they saying that they don't understand what's going on, but they do. And they don't want to admit to it because they're not going to openly admit that you beat them. Okay? You're only a damn fool to believe that type shit. That's ignorance. Alright? So, further, the Jefferson County Attorney's Office recognizes that the court may not have jurisdiction. Let me redo that again. Let y'all see. Okay? Hoodoo. Look at this. Further, the Jefferson County Attorney Office recognizes that this court may not have jurisdiction, okay, to review such motion at this time, okay. Then why would she make a motion? Because they said they'd be happy to make a motion, but we didn't ask them to do that. You know, doing too much. However, as the petitioner filed at least one of these notices of record in the paternity action, the cabinet requests, okay, that means they don't have power, right? The cabinet requests the assistance of the court, okay? They asking the court to please, this brother got some powerful shit, we don't want none. Alright, determine the relief requested by the petitioner and whether such request is appropriate at this time. Okay, further, the intervening petitioner incorporates, there it is, the audit, alright, of child support arrears, which is previously provided to the petitioner by mail, 2017. There she go. Lori E. Taylor. Now check this out. Look at this order. She wrote this order. Ain't no signature on it. Look at that. Petitioner shall bring the following documents to the hearing. No. No. To this ward? No. Nah. Nada. No. You ain't got that type of authority. Check this out. That's why I said he is the petitioner. And to him at this address. You know what I'm saying? Lord E. Taylor is some deep doo-doo. Okay? Baby mama right here, she'd have responded. Counsel for the petitioner. Now, fellas, like I said, y'all need some help. Hit us up, subscribe, like. This is More Proof Part 2, Moor-runs. And that's how we breaking this shit down. You know? Piece of cake. Shit ain't hard. Stop being bitches. Gonna come over here. Handle your business. Alright? Because you know you can't read. You know it's hard for you to understand what's going on. Don't be a Mr. Smart Ass and do all this shit. And no. Go on and invest in yourself so you have to worry about this shit no more. Alright? Peace.